morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Michael Cole, inmate number 386420. Today is Tuesday, March 18th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Michael Cole, 386420.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Good morning, Hannah Dean for the record on behalf of Mr. Cole.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Cole, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges of the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Mr. Cole, do you have any questions about the purpose or procedure before we begin?
No.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges of the state your parole officers bringing against you and the information underlying each charge. Charge 1, reporting. On October 15th, 2024, P.O. Ligon attempted a home visit. Subject was not home at the time. Subject reported to Hartford District Office on October 15th, 2024, when P.O. was at his residence for a home visit. Subject was directed to stay to be seen by another P.O. Subject was not seen despite this officer's attempts to have him seen. Subject left without P.O.'s permission. On October 17th, 2024, P.O. Ligon sent subject text to report to Hartford District Office by 11 a.m. on October 17th, 2024, and he failed to report as directed. P.O. contacted the subject's federal probation officer and informed her that this officer was attempting to get in contact with the subject for reporting. She stated she would call him and direct him to report to the Hartford District Office by 2 p.m. on October 17th, 2024. Subject failed to report on October 17th, 2024. On October 25th, 2024, this officer made telephone contact with the offender's aunt/sponsor, Nikki White, who informed me that she was not home and neither was Mr. Cole. I gave her my contact info and was asked her to give Mr. Cole reporting instructions for October 28th, 2024 at 11 a.m. On October 28th, 2024, Mr. Cole did not report to the Hartford District Office at 11 a.m. as directed. Charge 2, program participation. You failed to attend your scheduled domestic violence program with Wheeler Clinic on July 17th, 2020, or July 15th, 2024. You did not have permission from your parole officer to miss your scheduled group. Charge 3, absconder. On October 11th, 2024, P.O. Ligon informed Mr. Cole that she would be conducting a home visit at his residence on October 15th, 2024. Mr. Cole was not at home for this scheduled home visit. On October 17th, 2024, P.O. Ligon sent Parole a text message to report to Hartford District Office by 11 a.m. He failed to report as directed. On October 25th, 2024, this officer made telephone contact with the parolee's aunt/sponsor, Nikki White. This officer gave Ms. White my contact info and asked her to give Mr. Cole reporting instructions for October 28th, 2024 at 11 a.m. On October 28th, 2024, the offender did not report to the Hartford District Office as reported. Charge 4, obedience to the law. On January 9th, 2025, at the time of your apprehension related to your absconder warrant, you had an active arrest warrant as prepared by U.S. Probation. Current charges, supervised release violation. Charge 5, behavior management program. You failed to attend your scheduled domestic violence program with Wheeler Clinic on July 15th, 2024. You did not have permission from your parole officer to miss your scheduled group. The state has filed the following exhibits. Exhibit A, parole and community services signed conditions. Exhibit B, remand to custody. Exhibit C, notice of parole violation and notice of parole rights. Exhibit D, parole violation report. Exhibit E, Wheeler Clinic / Explore report. Exhibit F, domestic violence program referral. Exhibit G, misconduct reports. Exhibit H, text messages between P.O. Ligon and Mr. Cole. Exhibit I, U.S. probation arrest warrant dated November 26, 2024. The state has also filed an addendum to Exhibit D, which states on February 3rd, 2025, Mr. Cole's supervision was revoked, and the court imposed a 1-year term of supervised release to begin upon his release from his respective DOC facility. Counsel, did you receive the notice of parole violation report, and other documents that were just marked for identification purposes?
Yes, I did.
And defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel?
Yes, thank you very much. As to charge 1 reporting, I just have some general comments to that charge and charge 3. My client reports being in the halfway house for approximately 4 months without issue. He eventually asked his aunt if he could sponsor over to her house that she could parole him over there. And she did say yes. My client went through the process successfully of having her become a sponsor. However, when he actually went there, she wouldn't allow him to stay. So he thereafter needed somewhere to stay and ultimately went to live with a family member. I did just want to provide some context to those charges. As to charge 2 and charge 5 regarding the domestic violence programming, Exhibit E does not indicate whatsoever that it was an unsuccessful discharge from the program. In fact, it notes that my client had I believe 10 sessions that he had attended with only 1 absence, and that my client was just being transferred from the Middletown location of the program to the Hartford location. There's nothing else in evidence that suggests he didn't follow program rules or that he was unsuccessfully discharged for any reason. 1 mispass alone, especially when my client was still engaging in the treatment, isn't enough to rise to the preponderance standard. So I would argue that no findings should be made for those charges. And as to charge 4, I would just note the obedience of the law, the situation was resolved. It was a federal violation of probation. My client essentially has 1 year of additional supervision now, but the case was resolved. I would argue that for that specific charge, the preponderance standard hasn't been met because this is not a new charge or a new criminal conviction. My client didn't plead guilty to a new charge. He essentially just admitted to a status, which is what typically happens on violations of probation. Since this is not a new criminal offense regarding new criminal conduct, I would argue that the preponderance standard hasn't been met. And at the appropriate time, I would like to remark on his background and history. Thank you.
Thank you. I'm going to take a moment before I announce my findings. Regarding charge 1 reporting, I make a no finding on part 3 as the state failed to provide sufficient evidence that Mr. Cole's action meets the elements of the charge. I make a finding on parts 1 and 2 based on state's exhibits A, D, G, and H. On charge 2, program participation, I make a no finding as the state failed to provide sufficient evidence to prove that Mr. Cole's actions meet the elements of this charge. Charge 3, absconder, I make a no finding on part 3 as the state failed to provide sufficient evidence that Mr. Cole's actions meet the elements of this charge. I make a finding on parts 1 and 2 based on state's exhibits A, D, G, and H. On charge 4, obedience to the law, I make a finding based on state's exhibits A, D, and I. On charge 5, behavioral management for domestic violence, I make a no finding as the state failed to provide sufficient evidence to prove that Mr. Cole's actions meet the elements of this charge. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, just briefly before I get started, Mr. Cole, when my social worker had spoken to you, we weren't sure of a specific sponsor. Do you have a sponsor at this point?
Yes.
Can you give me that person's information just so I can provide it to the hearing examiner?
All right. The name is Amber.
Amber, this is your
Yeah.
partner, right?
Yeah.
Okay. What's her last name? And then if you have her phone number, just so I can provide it.
I don't know how to spell it. I don't know how to say it, but I can spell it to you.
Okay.
Schryer.
Schreier. Okay. And then do you have the address and the phone number?
331 Park Street, apartment 1E, New Britain, Connecticut, 06010.
Okay. And then do you have a phone number for her?
203
Okay.
6005512.
Perfect. Thank you so much. So my client, Mr. Cole, is 31 years old. He was born and raised in the Hartford, Connecticut area. His primary source of support is his partner or significant other, Amber Schreier. His housing situation from May 2024 until October, he successfully completed the Connections Halfway House program in Middletown. Beginning in October 2nd, he was sponsored by his aunt in Hartford. Most recently, my client was actively searching for work. He was last employed in 2019 as a dishwasher in New Haven. While on supervision, he was, like I said, actively searching for employment. He participated in the Explore program. I believe he had completed approximately 10 sessions of that. He also successfully completed outpatient substance use therapy at Rushford in Middletown. And then my understanding is that he had himself voluntarily enrolled in that specific programming. He is supervised on federal probation by PO Moran, so he will have some additional supervision when he reenters the community. He reports that since his incarceration, he's been employed in the kitchen at Osborn since February of this current year. His position is every day of the week from 4:30 a.m. until 12 p.m. He has not gotten any DRs or disciplinary actions during this specific incarceration. He's amenable to any sort of treatment that is recommended and to all available job opportunities. He is interested in getting a job again in the restaurant industry or potentially looking into landscaping. He is also hoping to obtain his GED once he gets out to enhance future job prospects as well. Like I said, he's open to any treatment, including successfully completing and finishing that Explore program. My client's been in over 2 months. As I said before, he already has now additional federal supervision. I would argue that his sanction should not exceed 3 months. This isn't a situation where there were new criminal charges. It was a violation of his federal supervision, but he didn't pick up any new criminal charges. And I do think that he has learned his lesson during this period of remand. So I would argue for a sanction not to exceed 3 months. Thank you very much.
Thank you. I'm just going to take a moment before I announce my recommendation. Okay, Mr. Cole, I have that you've been on supervision since September. So you were discharged to special parole in September 2019. And since then, I have that this is your third violation and your second time absconding from parole supervision. You are also being supervised by federal probation at the same time you were being supervised by special parole. taking into account that this is your second time absconding, you were on dual supervision, I recommend revoke and re-parole on January 9th, 2026, which is an approximate 1-year sanction. Before I recommend my conditions, counsel, do you know if your client is currently serving a sentence for federal probation as well? I know he's on probation. Is there a consecutive sentence running as well?
Not that I know of. I don't
Okay.
believe so. Is there a consecutive sentence to your federal probation, or is it just that 1 year that they gave you to serve once you get out?
So they gave me 1 year on the house arrest. So if I can complete the 1 year on house arrest, they'll drop the 2 years left because I got 3 years on federal probation.
Okay, I
So
see. Thank you.
they made a little deal with me.
Okay, thank you.
So I recommend the following conditions: no consumption of alcohol, domestic violence, no contact with co-defendants RR, JC, JS, and LS, no contact with victims PD and EV, a general no contact with AC and mental health evaluation. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board, and your board review is scheduled on March 27th, 2025. So that's next Thursday. The board may lessen my recommended sanction. They can let my recommended sanction stand, or they can impose a sanction longer than what I have recommended, being that you're on special parole until August 2026. If they decide to exceed my recommendation, another hearing will take place, which is called a supplemental hearing, but you will receive that in writing in the event that they do, regardless of what, you receive everything in writing. But if they choose to have a longer sanction, you'll be given reasons as to why. Okay, so that does conclude your revocation hearing.
Mr. Cole, I will set up a legal call with you so that we can touch base after the board review and I can let you know what they decide, okay?
Okay,
All right, thank you very much.
Thank
you're
you.
welcome. Thank you.
Have a good day, ma'am.
Thank you.
You're welcome. You're probably gonna have to disconnect me. Oh, here we go. I think it's gonna work.
Good morning.
Morning.
Do you have anyone there yet? I know it's a little
Yes.
early.
Yes,
Who
I
do you
have
have?
them all here.
Oh, okay. So yeah, we can start it with Mr. Hernandez, but we're not gonna get started for another few minutes.
Okay, I'll just have them come in at 9, okay?
Perfect, thank you.
Okay, great.
Good morning, P.O. Huff.
Morning, how are you?
Good, good. We'll get started right on time at 9:30.
Sounds good, thank you.
Thank you.
All right, would you like them in now?
Yeah, you can bring them in. Thank you.
After Hernandez, who would it be? Do you know?
You can have Mr. Perez.
Okay, great, thanks. Hernandez.
Morning, Mr. Hernandez.
Morning.
We're going to get started in about 3 minutes.
Okay.
Thank you. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Eduardo Hernandez Jr., inmate number 295416. Today is Tuesday, March 18th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Eduardo Hernandez, 295416.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney,
Good morning, Hannah Dean, for the record on behalf of Mr. Hernandez.
as well as your parole officer, Huff.
Officer Huff, Hartford Special Management Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony in today's hearing will be taken under oath. Mr. Hernandez and P.O. Huff, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. The state, as well as your attorney, will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, the state and your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges of the state Bureau Parole officers bringing against you and the information underlying each charge. Charge 1, GPS, P.O. Huff.
You failed to charge your GPS as directed, resulting in a GPS shutdown on 10/4/2023 from 2:05 a.m. until 3:10 a.m. Your GPS shut down again on 10/6/2023 from 12:08 a.m. until 2 a.m. and again on 10/9/2023 from 12:57 a.m. until 1:52 a.m. You were unaccountable in the community during these GPS shutdowns.
Charge 2, curfew.
On 12/6/2023, you did not go straight home from work as previously directed. You went to Newington and did not return home until 11:37 p.m.
Charge 3, obedience to the law.
On 1/24/24, you drove your gray Honda Accord to a residence in New Britain where you assaulted your girlfriend to the point where she and all the witnesses feared for her life. Police were called and located you in your vehicle. You were charged with violating the following Connecticut General Statutes: 53A-60B, assault to victim, elderly, or other; 53A-182, disorderly conduct; 29-17, failure to comply with fingerprint requirements; 53A-167A, interfering with officer and resisting; and 53A-96, unlawful restraint in the second degree. You arraigned on 1/25/2024, where probable cause was established and bond was set at $100,000.
Charge 4, drugs.
On 11/29/2023, you rendered a urine which tested positive for cocaine. You denied using cocaine, but the lab confirmed the presence of cocaine metabolite. On 1/17/2024, you rendered a urine which tested positive for cocaine. You again denied using, until later you texted your parole officer admitting that I slipped up, I thought I would have been clean, and that's why I didn't come straight with you. The lab confirmed the presence of cocaine metabolite.
Charge 5, no consumption of alcoholic beverages.
On 9/21/2023, after refusing a breathalyzer test upon returning to the halfway house, you rendered a urine which came back positive for alcohol.
Charge 6, halfway house placement.
On 9/21/2023, you were unaccountable in the community as you did not return to the halfway house until over 6 hours after your scheduled return time. Upon your return to the halfway house, you refused staff orders to submit to a breathalyzer test. You rendered urine which tested positive for alcohol. On 9/26/2023, halfway house staff witnessed you park and exit a gray Honda Accord upon returning to the halfway house from a community pass. You're directed by your parole officer not to operate a motor vehicle. These actions are in violation of your signed halfway house agreement.
Charge 7, no driving.
On 9/26/2023, halfway house staff witnessed you park and exit a gray Honda Accord upon returning to the halfway house from a community pass. You were previously directed by your parole officer that you are not to operate a motor vehicle. On 10/25/2023, during a visit to your residence, your parole officer noticed your gray Honda Accord was not there. A phone call was then made to you, and you admitted to operating a motor vehicle without your parole officer's permission. On 1/24/2024, you drove your gray Honda Accord to New Britain where you assaulted your girlfriend.
The state has followed the following exhibits, starting with Exhibit A, P.O. Huff.
Parole and Community Services signed conditions. Exhibit B, remand to actual custody. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, signed misconducts with evidence. Exhibit F, signed halfway house agreement. Exhibit G, signed GPS monitoring agreement. Exhibit H, State of Connecticut Judicial Branch pending case detail. Exhibit I, 2 ring videos from 1/24/2024. Exhibit J, New Britain Police Department Incident Report 24-002232. Exhibit K, Premier Biotech Lab Report with texted admission.
The state has filed an addendum to Exhibit D, which states on February 11th, 2025, Mr. Hernandez pled guilty to the substituted charge of assault third. Mr. Hernandez was sentenced to 11 months jail under docket number ending in 179. Mr. Hernandez also pled guilty to violation of a protective order and was sentenced to 5 years jail, execution suspended after 2 years, followed by 3 years probation under docket ending in 013. Counsel, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
I have.
And defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses. At this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. P.O. Huff.
Yeah, just regarding offender Hernandez, this criminal violation, as his previous violations, are preceded by numerous misconductable offenses. Hernandez has established quite the cycle of coming back on parole supervision and exploiting the fact that parole has become much more lenient when it comes to technical violations. He has established a cycle of doing what he wants to do with little to no regard for what the Board of Pardons and Paroles, his parole officer, the police, and even the judge in this case direct him to do or not to do. In this case, the judge put a protective order in place against Hernandez at his arraignment for his criminal violation, and less than 24 hours later, he's violating the protective order by calling the victim from, attempting to call the victim from jail. This kind of sums up Hernandez in a nutshell. He was released from the halfway house in August of 2023, and a little over a month later, his continued pattern of non-compliant behavior continued in the form of misusing the halfway house pass system, refusing breathalyzers, consuming alcohol, operating a motor vehicle, and he also begins mounting numerous GPS violations. This all occurs within the 2 months of him residing in the halfway house. He's also, within the 2 months that he's at the halfway house, he's finally able to secure a room at a rooming house, and his pattern of non-compliance continues to worsen. He continues to operate motor vehicles without permission, use cocaine, disregard parole officers' directions regarding his curfew, and to stay out of New Britain, as a lot of his cases have stemmed from there. After all these misconductable offenses, and despite attending substance abuse treatment, sex offender treatment, and the Explore program for domestic violence, 5 months after his third re-release to special parole supervision, he leaves work, ignores his curfew, drives to New Britain, where he's previously directed to stay out of, and violently assaults a woman who is legally blind. During this assault, he tells her, "I'm going to get out and you're not safe," calling her a one-eyed bitch. As a result of this assault, the victim was transported to the hospital for treatment and evaluation. Upon visiting Hernandez, when I went to go serve him his notice of parole violation, he attempted to play the victim card, stating that he was jumped and hit in the head with a baseball bat in an effort to minimize the situation, unaware of the video footage which was obtained that shows this violent assault. And that's all I have for now.
Thank you. It is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel?
Yes, thank you very much. As to charge 1, GPS, I just want to note that for each of those violations, they were only approximately 1 to 2 hours in length, and there were no allegations that my client was out in the community during those alleged violations, or that he violated curfew on those specific dates. So I would argue that for all of those violations that are GPS, he wasn't unaccountable in the community. He was likely in his residence or the halfway house, specifically because there were no accompanying curfew violations there. As to charge 3, I have no comments. The addendum is accurate. My client does have a new conviction where he will be serving, I believe, 523. So he already got a significant penalty in criminal court. As to charge 4 and 5, drugs and no alcohol, I would just argue the alleged text message from 1/17/24. The texts that were submitted as evidence at Exhibit K are black. You can't see what they say at all. I would argue those exhibits should not be considered, or any admission there should not be considered, because we don't have the contents of those in evidence. And then as to the remaining charges, I just do have some global comments. My client has been incarcerated for over a year at this point on these charges. So all of these allegations are from well over a year ago. He will be on additional supervision in the form of probation when he enters the community. And I will also note that despite the misconducts and other issues, my client was still engaging with the halfway house. He was still reporting. He always returned despite the potential violations, and was eventually even approved for his independent residence. So I would just leave my comments there, and at the appropriate time, I would like to remark on his background history.
Thank you. You'll help anything further?
Yeah, that's how we can say they're only for, an hour or so. We're just minimizing the behavior here. And also those texts that I provided as evidence, those are from my state issued cell phone, and I'm testifying under oath that those are from the offender Hernandez, which he can probably admit to as well if you'd like to talk.
I would just note that's not what was submitted in evidence. What we have submitted in evidence are just blacked out texts. We don't have the contents of those. I understand that they were from the PO's state issued cell phone. I'm not contesting that. My argument, though, here we are determining whether there's been a preponderance of the evidence to establish that a violation has occurred. And I would argue that without the contents of those messages, we can't for that specific charge. But that's it. And then I would like to remark on his background history. Thank you.
I'd be more than willing to read those to you if you'd like. I know that sometimes the scanning doesn't go through as it should. On my end, it appears that it's readable anyways. I'm sorry if it didn't come through as it does on my end anyway. So I can read those if you'd like.
Yes, please, P.O. Huff, because on my end as well, it is black as well.
Okay.
So it was
Sorry about that.
Wednesday, January 17th at 4:07 p.m.
Let's see.
Exhibit K.
Yep, this is, again, its headline says that Eduardo Hernandez has his inmate number. That's how I have it on my phone. He texted at 4:07 p.m. I want to apologize. The first time I really don't know how I popped 30, but I slipped up. I thought I would have been clean, and that's why I didn't come straight with you. But when I go in on Tuesday for group, I'm gonna tell Frankie that I want to do IOP. Sorry for disappointing you, but thank you for being patient with me. I am going to get everything in order all around. Thank you for acknowledging my accomplishment. I won't let you down or myself.
Thank you.
And there's also the one from, I'm sorry, go
Go
ahead.
ahead, sorry. Go ahead.
And then you, the text, I think this is the only other one that's provided from Wednesday, October 25th at 11:50 a.m. This is when I was at his residence and I called him, noticing that his car was gone. He was not present at the residence. I called him, noticed that his car was gone. He admitted to me over the phone that he was driving. He texted back saying, I'm sorry, I tried to get a ride and I don't have the money for Uber. I had an appointment at Wheeler Clinic at 10:40. Then I came straight here to 21 South Road, Farmington, Connecticut, to see if I have colon cancer. Then I'm going back home and I'm going to work once again. I'm sorry, I'm just trying to take care of myself. And then he texted again, I'm home, car parked.
Thank you. Also,
Just briefly, I would just note, he was keeping the PO informed of his whereabouts, and he was also being forthcoming when it came to relapse. And it sounds as though he was trying to engage in services recommended. Those are my final comments. Thank you.
thank you. And P.O. Huff.
That's all I have for now. Thank you.
Thank you. I'm just going to take a moment before I announce my findings. Regarding charge 1 GPS, I make a finding based on state's exhibits A, D, E, and G. Charge 2 curfew, I make a finding based on state's exhibits A, D, E, and G. On charge 3 obedience to the law, I make a finding based on Mr. Hernandez's conviction as well as state's exhibits A, D, H, I, and J. On charge 4 drugs, I make a finding based on state's exhibits A, D, E, and K. On charge 5 no consumption of alcoholic beverages, I make a finding based on state's exhibits A, D, and E. On charge 6, halfway house placement, I make a no finding on part 1, as the state failed to provide sufficient evidence to prove that Mr. Hernandez's actions meet the elements of this charge. I make a finding on part 2, based on state's exhibits A, D, E, and F. On charge 7, no driving, I make a finding based on state's exhibits A, D, E, F, and I, and as well as Mr. P.O. Huff's testimony in regards to reading the text messages. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney as well as the state will have an opportunity to hear background history. P.O. Huff, would you like to make a statement regarding Mr. Hernandez's background history at this time?
Sure, just a brief history on Hernandez and what brings us to where we are today. 2001, Hernandez was sentenced to 8 years, suspended after 9 months, served by 10 years probation for an offense where he forced his minor-age sister to perform oral sex on him. During that period of probation, he violated probation 4 times before being sentenced to 4 years. He again violated probation in the commission of his instant offense in April 2012, where he was in New Britain and his biological 8-year-old and 10-year-old daughters were spending Christmas with him. His 10-year-old daughter also suffers from cerebral palsy. The 8-year-old daughter stated that he touched her vagina over her clothes, while his 10-year-old daughter stated, again, this is the one that has cerebral palsy, describes the incident in the living room where offender engaged in sexual intercourse with her. He told his 10-year-old daughter that if she told her mother, if she said anything, that he would kill the mom. So that's what brings us to his instant offense here. He was sentenced to 9 years, followed by 10 years of special parole. He's also established quite the pattern of non-compliance since being released to special parole supervision, beginning on December 30th, 2020. He was released from the January Center on March 15th, 2021, which is an inpatient sexual treatment facility, which it's pretty much like it's inpatient. He can't leave. Upon being released from there, it took him 9 months in the community before he violently assaulted a different girlfriend, Miss Shauna Carrara, while driving and drinking, resulting in his first remand to custody. This was reported to police by bystanders. When he was taken into custody, he became belligerent with police, and he was released a mere 90 days later after another victim was added to his conditions. I don't know where she is on the conditions now. She's not on the conditions that are her most updated ones. But yeah, he was released a mere 90 days after this assault. Less than a month later, after his re-release, he was back to his non-compliant behavior with curfew and GPS violations. He was abusing cocaine, fentanyl, and alcohol despite being engaged in substance abuse treatment. On June 4, 2022, he was discovered unconscious in his apartment by Vernon police, who had to administer 2 doses of Narcan. 10 days later, he was again arrested and remanded to custody for possession of narcotics, paraphernalia, and drug paraphernalia. When he was taken into custody again, he became belligerent, yelling, "Fuck it, fuck you, I ain't doing shit, I ain't going to jail for no reason. I want to do my whole bid. If I come out, I will do worse on purpose. I'll do whatever the hell I want to do," which is what he continues to do. "I'm going to keep doing this shit for the rest of my life. I don't care, and parole can't stop me." He received another unconditional discharge by the court, and he subsequently served a 5-month sanction for this behavior. 6 months after his second release, New Britain police found him unconscious behind the wheel of his vehicle. Once they're able to awaken him, he appeared to be under the influence of drugs and/or alcohol, and refused police commands to get out of the vehicle. They had to forcefully remove him from the vehicle, and he again became belligerent with police. Police interviewed the family members, who stated that he had been at a family party drinking all day. Due to his actions, Hernandez was placed under arrest for violating Connecticut General Statute 53A-167A, interfering with an officer. During the booking process, police attempted to ask Hernandez basic information. And during the fingerprinting process, he once again resorted to his continued pattern of belligerence when confronted with the consequences of his actions, repeatedly yelling, "Fuck you, what the fuck you want," rather than allowing officers to proceed with the booking process. He received an unconditional discharge from the court for interfering and resisting on June 1st, 2023. Again, after 3-month sanction, he was re-released for the third time on August 10th, 2023. Upon his release, I directed him that he's not to operate a motor vehicle or go to Britain due to many of his issues originating in the city. He was referred to and enrolled in the Explorer program for domestic violence, as well as the Connection Center for the Treatment of Problem Sexual Behavior. A little over a month following his re-release, he tested positive for alcohol. He was seen operating a motor vehicle, and yeah, it's pretty much, I could repeat what I had initially stated before, but I'm just going back into his recent arrest. The video is very concerning. The severity of this assault, we only get, I think, a 10-minute snippet of it, but this is just Hernandez's behavior, and this is what he continues to do. And if released to special parole, I would recommend that his parole be revoked and he not be re-paroled. But if he is to be re-paroled, I would recommend at least another year sanction on top of what the court has already sentenced him to. That's all I have for now.
Thank you. Counsel?
Yes, I would just like to start by noting that, rehashing the allegations of my client's underlying offenses, that's not new conduct here. Those have to do with, sentences for which my client has already served his time, and the instances for which he's currently on parole. All the prior convictions for which my client had gotten sanctions while on parole, all of those were resolved. He served his time or took the penalty. A number of those were unconditional discharges, and he did serve all those sentences and all of the appropriate sanctions thereafter. I just want to note that. As to his background and history, my client's 40 years old, born in Brooklyn. He lived in Puerto Rico for a little while before moving to New Britain in 1988. My client gets some significant support from his family, including his mother, father, his brothers, as well as 3 close friends of his. He has 4 children as well, 3 daughters and 1 son. I don't believe he has contact with at least a couple of those children due to one of the prior cases, the protective orders in that matter. Most recently, upon release to special parole in August of 2023, my client successfully completed the open hearth halfway house in Hartford. And thereafter, he was self-sponsored at a rooming home in East Hartford, where he remained until he was remanded. My client returned to his full-time position at Sardilli Produce and Dairy when he was released. He also participated in Explore DB program at Wheeler Clinic. He had done, I believe, 23 of the 26 sessions. He also had been doing outpatient treatment as well at Wheeler Clinic. He was initially doing IOP and then stepped down to individual therapy. He also was doing medication management there. He reports that he participated as well in the CTPSB program and was in phase 2 of that program at the time he was remanded. While in the community, my client was on a maximum contact schedule and his regularity of contact was good. So he was keeping in touch with parole. He was compliant with the sex offender registry requirements. Since being incarcerated on the remand, my client has been employed as a tierman in the facility. He's been medication compliant and has had no DRs, no disciplinary reports since being in. On reinstatement of special parole supervision, my client would like to be placed in a halfway house in the Hartford area due to the proximity to his prior job and also treatment providers. He's hoping to return to his full-time position at Sardilli Produce. His supervisor is Charles, who can be reached at the phone number we provided. I believe they are keeping that job open for my client. He's open to any sort of treatment recommended, including successfully completing the Explore program and the CTPSB program. Again, he had done quite a bit of the Explore program, only had about 3 classes left. He would also like to establish clinical services again at Wheeler Clinic, including his medication management. I'm asking that a sanction for my client not exceed 12 months. He's already been held on this remand for over a year at this point. He also received a fairly lengthy sentence out of the criminal court where he's going to have 2 years to serve. I think anything on top of that is a bit outrageous for the specific violation that we're currently on. I think that that's more than sufficient. My client will also as well have additional supervision when he leaves incarceration. He will have probation who's involved in addition to parole. So with all of that in mind, I would ask that the same should not receive 12 months. Thank you.
Thank you. Do you have anything further?
I think I should be good. I just want to, the best predictor of future behavior is past behavior. And so again, this will be his 4th re-release, 4th opportunity at special parole. It's at one point, do we, call it what it is? That's
And I would just note, though my client has had community release failures, he's also had at least 1 community release success. I do just want to make that clear.
Thank you. And if you have anything further?
No, that's it. Thank you.
Thank you. And counsel, anything?
No, thank you.
Thank you. I'm going to take a moment before I make my recommendation. Actually, I'm going to take a recess before I make my recommendation. Okay, now back on the record. Mr. Hernandez, being that you've been on special parole since December 2020, and this is your fourth violation. From what I have, I believe it's your third criminal violation since being on special parole. You were in the community for about 5.5 months, and taking into consideration your current violation as well as all the information submitted here today based off of your appeals testimony as well as your defense counsel, I recommend revoke and reparole on January 25th, 2027, which is an approximate 3-year sanction. Before I announce my conditions or my recommended conditions, P.O. Huff, I just have a quick question for you. You had mentioned in your testimony earlier a victim in the first violation.
In the first assault, that was Ashana Carrara. I'm not sure why she's not on the conditions anymore. I'm not sure where she is. I just don't know why she's not on the conditions anymore. It's something that I realized after the fact. And then there's also, I would recommend that the victim in this case as well be put on those conditions as well.
Okay, so you are recommending that this victim be added to his parole conditions?
Please.
Okay, is he currently serving a sentence for this victim for the alleged charge in that first violation?
No, that was an unconditional discharge.
Okay, so being that he's not currently serving a sentence, it would have to go under general no contact. So would you
Okay. Yeah, I'll support
be
that.
recommending a general no contact with this woman?
Please.
And what is her initials?
SC.
SC. Okay.
And then
I
also
recommend the
TG for this case.
Yeah.
Thank you.
Thank you. I recommend the following conditions: no consumption of alcohol, domestic violence, no contact with victims AC, AH, and TG, no contact with minors, halfway house placement, mental health treatment, no operation of a motor vehicle without the express permission of your parole officer, problem sexual behavior treatment, a MOA condition in the event that the board does lessen my recommended sanction, as well as a general no contact with, you said SC, correct?
Yes, ma'am.
Okay.
Yo, Saunders, I have a quick question.
Yeah.
Does the first sign of alcohol, is that still a condition?
Yes, I have no consumption of alcohol, yes.
Does the first sign of alcohol, return upon first sign, does that still exist?
It's just I'm not aware of that.
Okay.
Is this a general no consumption of alcoholic beverages?
Okay.
The condition,
Thank you.
yeah.
There used to be a first sign of consumption that would be able to bring them back, but that's all. All right, thank you.
Okay. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board, and your board review is scheduled on March 27th, 2025. On that day, the board is going to take a look at your case, which is next Thursday. They can lessen my recommended sanction, they can adopt my recommended sanction, or they can exceed my recommended sanction, being that you are on special parole until December 2030. Whatever the board decides, you will receive in writing within that week from March 27th, okay?
So you ain't-
Sir,
Yeah,
I will set up a legal call with you for either the afternoon of the 27th or the following day, so we can discuss what the board decides, okay?
all right, so they didn't decide nothing?
So right now, the hearing examiner made a recommendation for a 3-year sanction with you getting out on 1/25/27. The board has the final say. So that recommendation goes to the Pardon and Parole Board next week on the 27th. They can either say, yes, that sounds good. They could give you less time, or they could, in theory, give you more time. If they do give you more time, you and I would get an additional hearing, okay?
So that's in 2 more years?
Yes, she gave, yep, yes. So that's the recommendation. We'll know for sure what the board's doing next Thursday. So I'll set up a call with you so we can discuss, okay?
Yeah,
All right, thank you.
And P.O. Huff, can you just spell the general context first and last name for me? I just want to make sure I have the correct spelling.
Is that Tiffany Guz, Guz, and
was
Shauna
that?
Carrara?
No, Shauna. Okay.
Yes, it's SHAWNA Carrara is Carrarra.
Okay, thank you so much.
Thank you. Have a good day.
You too.
Hello.
Ready for Mr. Perez.
Okay, so you're done with the other guy, right? Hernandez?
Yes, we're all set.
Okay. Perez. Stand by for me a minute. Let me call the first.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Luis Perez, inmate number 389906. Today is Tuesday, March 18th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Luis Perez, 389906.
This is a public hearing. Public access to this hearing is available via video live stream. This is a preliminary hearing which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to prove that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Perez, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
Yes.
What do you have questions?
Yeah. Wasn't I supposed to have an attorney here representing me as well?
So you have not
I
been
have
assigned, you haven't been assigned an attorney, but I was going to read you your rights, which you have the right to be represented by an attorney. So would you like an attorney? Would you like attorney representation?
Yes, I have filled out for that before I even came in here. Like I circled yes on the paper.
Okay. So if you would like an attorney, again, you haven't been assigned one. So what we could do is continue your hearing until my next hearing is next Monday, March 24th. And we can make sure.
I don't want to slow. I just don't want to. I don't want to slow anything up, anyways. Either. You know what I'm saying?
I mean, it's up to you. I mean, you have to see if you're eligible for an attorney representation. It's Monday, March 24th. It's up to you if you want to continue the case, so that you can see if you qualify for an attorney, or we could proceed today with moving forward without an attorney. It's completely up to you.
I just don't want to get railroaded, miss. I ain't even gonna lie to you. I'm not even going. I'm not lying to you. I'm like, cause what do you feel is the best decision?
I can't make that decision for you. Again, if you would, so my next available hearing is Monday.
All right,
which is the 24th.
We'll move forward. We'll move forward with this. We could just.
So
do
you would
this
like to
right now.
proceed today without an attorney?
Yeah, because I feel like I feel like I'll be able to explain to you good enough.
So again, you have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney, and you may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So to clarify, do you intend to seek counsel for this hearing or proceed without counsel?
Proceed.
Without counsel?
Yes.
Okay. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your parole officers bring against you and the information underlying each charge. Charge 1, GPS. You signed a GPS agreement on December 22nd, 2021. On May 7th, 2022, you had a GPS battery shutdown from 11:58 a.m. to May 8th, 2022 to 1:16 a.m. On May 10th, 2022, you had a GPS battery shutdown from 3:48 a.m. to 5:10 a.m. On May 23rd, 2022, you had another GPS shutdown from 2 p.m. to 11 p.m. to 6:18 p.m. Charge 2, obedience to the law. On February 26, 2025, West Hartford police officers stated they pulled over the vehicle you were driving. They stated you were driving with 2 other individuals in a rental vehicle. Officers searched the vehicle and found $10,000 to $20,000 in cash. Officers also found over 5 ounces of marijuana in the vehicle. Subsequently, you were arrested for possession of 5 ounces or more, 8 ounces of the locked cannabis, placement 21 years older, conspiracy to commit possession of 5 ounces or more, 8 ounces or more locked cannabis, placement 21 years or older or more, conspiracy to commit possession with intent of a hallucinogen substitution, possession intent, hallucinogen, and substance, intended auto glass requirements. The state has filed the following exhibits. Exhibit A, conditions of parole. Exhibit B, Connecticut Board of Parole remand to actual custody. Exhibit C, notice of parole violation and notice of parolee rights. Exhibit D, parole violation report. Exhibit E, West Hartford Police Report. Exhibit F, State of Connecticut Board of Partisan Paroles Decision Information Summary. Exhibit G, State of Connecticut Judicial Branch Pending Case Detail. Exhibit H, Offender Misconducts. Exhibit I, GPS Agreement. And Exhibit J, View Offender Allied Universal Electric Monitoring Manager Position History. Mr. Perez, did you receive the notice of parole violation report, and the other documents that I just marked for identification purposes? It should have been a parole package you received.
Yes, I received a parole package, and that's what I wanted to talk to you about, right? I have a paid lawyer, and I got court on the 31st. I never got charged on, I don't know if you got the full police report and stuff like that, but they had hit me with possession of hallucinogens, which my lawyer is going to try to get removed because I never got caught with no hallucinogens. There was no drugs in the car, no controlled substances in the car, or none of that. So that's why I'm going to court on the 31st to try to get all of that resolved, because I never got caught with no hallucinogens.
Mr. Perez, so we're going to get to the charges. I just want to make sure you received the parole package with all the evidence, and so you did review it. Did you have enough time to review all the evidence?
Yes.
Okay, I just wanted to make sure. So today we have no witnesses, and it is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time? I know you just made that statement, but would you like to make a further statement? It's your opportunity.
Yeah, no. So basically, this is basically I just got charged. I got charged with all the weed and the money, but the people that I was in the car with, they already took ownership for that. That's theirs. You know what I'm saying? So I'm basically just here because I'm at the wrong place at the wrong time. I never got caught with no drugs, and they trying to say that I got caught with hallucinogens. That's why I hired a paid lawyer, and I got to go to court on the 31st to get that disposed. You know what I mean? I was trying to explain that to my parole officer, but this guy is just, I already reported him too, because he being mad, disobedient. I'm not disobedient, disrespectful and shit to my people. Excuse me. He's being disrespectful to my people. And this is the only time that I even had to say any of this, because I never had no other time to explain this. You know what I mean? I don't know if you read the police report, but in the police report, it clearly states that I never got caught with no drugs. You know what I'm saying? So why are they hallucinating charge, or why are they possessing the intent to sell charges when people took ownership to their own stuff?
Anything further, Mr. Perez?
Also, just for the record, I do work. I pay my bills. I do have pay stubs. I am a working citizen. This is my first time being violated on special parole, and yeah, that's pretty much it.
Thank you. I'm going to take a moment before I announce my recommendation, or my findings and my recommendation. Regarding charge one, GPS, I make a finding of probable cause based on state's exhibits A, D, H, I, and J. On charge two, obedience to the law, I make a no finding of probable cause on the tinted auto glass requirement charge, as this is a motor vehicle infraction. I make a finding of probable cause on the rest of the offenses listed in this charge based on state's exhibits A, D, E, and G. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. So, Mr. Perez, what that means is you're going to remain incarcerated. I know you said you have a hearing on the 31st. So
I
you're,
got to go to court on the 31st.
yep. So on the 30, so your revocation hearing, so I did deem it serious to remain incarcerated while these charges are being heard, while you handle it criminally. So your revocation hearing will be scheduled upon the disposition of your pending case. So once your pending case is resolved, then you would be scheduled for a revocation hearing. At the revocation hearing, a hearing examiner will determine if you violated the conditions of your parole. And if so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanction should be imposed. Okay, so this does conclude your preliminary hearing. And again, once your pending charges are resolved, you'll have another hearing for your a revocation hearing.
Okay, so what else? So basically, I just got to go to court and get this resolved, and special parole will come see me.
Yeah, you'll have another hearing.
All right. Okay.
Okay. Thank you.
Alrighty.
Good morning, Mr. Marino.
Good morning, man.
So I'm going to try to get your parole officer on the line. He wants to participate as well. And then we'll get started.
Yeah.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Brian Marino, inmate number 328534. Today is Tuesday, March 18th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Brian Marino, 328534.
This hearing is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your parole officer.
Hi, P.O. Girard.
Mr. Marino, on the notice of parolee rights, you indicated you did not want to proceed with a preliminary hearing. Is this still your intent?
Yes, ma'am.
So before I accept your waiver, the waiver of the first part of this preliminary hearing, I have to go over some rights which you are waiving here today. So I want to make sure you're understanding what you're waiving. I know you were referred to the TOP program. Is that a part of why you'd want to waive the first part of this hearing?
Yes, ma'am.
So you're waiving the right to be represented by an attorney. You are waiving the right to receive written notice of charges of violation. You're waiving the right to review the evidence against you before this hearing. You're waiving the right to submit evidence in support of your hearing. You're waiving the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand the rights you are waiving here today?
Yes, ma'am.
I will accept the waiver. I have reviewed your case and made findings of probable cause that you have violated one or more of the conditions of your parole, and I have found that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. I now will proceed with the second part of this hearing regarding the diversion process. The Department of Correction has recommended you for diversion from the revocation process for substance abuse programming and treatment. This means that if you wish to participate and apply, and I find that you have met certain eligibility criteria, I can continue your case while you are provided an opportunity to participate in substance abuse programs and treatment in a correctional facility, which is the TOP program. If you successfully complete the program and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the programs and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated the conditions of parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process and do you wish to apply for diversion?
Yes, ma'am.
I will now announce my findings with respect to your eligibility. If I determine that you are eligible, I can accept your application and divert you from revocation. I have reviewed all relevant information and my findings are as follows. I find that you have no pending misdemeanor or felony charges. I find that your discharge date is more than 60 business days from the date of remand to actual custody. I find that there is evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of parole. And I find that there is some evidence that you received or were provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community. I have determined that you are eligible for diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask that you indicate whether you understand the following by answering yes or no. I understand that I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes.
I understand that ultimately the Department of Correction will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes.
I understand that my participation in this process is completely voluntary.
Yes, ma'am.
Your application for diversion is granted. You will be placed in treatment or programming by the Department of Correction and diverted from revocation for no more than 60 business days. So, Mr. Marino, this does conclude your preliminary hearing. I know you're already participating in the TOP program, so you are all set. Thank you very much.
Thank you, Ms. Saunders. See you later, John.
Thank you, P.O. Girard. Good morning.
Morning. Are you for Hernandez?
Yes.
Okay, Hernandez, come on over this side. Hernandez.
Yep.
This room.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Parties and Paroles. This is a revocation hearing concerning Luis Hernandez, inmate number 291110. Today is Tuesday, March 18th, 2025. This hearing is being conducted via video at the Board of Parties and Parole Central Office in Hartford Correctional Center. Please state your full name and DOC inmate number for the record.
Luis Hernandez, inmate number 291110.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make finding of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Hernandez, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you very much. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Yeah, because this is all a shock to me right now, because I got in the legal mail that my parole hearing, my revocation hearing was for April 8th. So nobody told me that they were moving it to today.
I mean, it's a little earlier. I mean, so.
Yeah.
Okay, so yeah, it's the same process, but it's today.
Okay.
We're moving forward to that.
Okay.
Any other questions or concerns?
No.
Okay. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without counsel?
No, I proceed without counsel.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, drugs. On or around December 28th, 2024, you used cocaine. On or around January 3rd, 2025, you used cocaine. Charge 2, halfway house placement. On January 6th, 2025, you signed out of the open hearth halfway house at 8 a.m. to report to CRT for IOP. You returned to the halfway house at 12:33 p.m. Upon investigation, it was discovered that you failed to report to CRT at all on this day, therefore making you unaccountable in the community for 4 hours and 33 minutes. This places you in clear and direct violation of your signed halfway house agreement. You do not have permission from anyone to be anywhere other than CRT. On January 15th, 2025, during a routine pat search of your person by Parole located a vape pen in your right front pocket. This places you in clear and direct violation of your halfway house agreement. The state's exhibits were marked and identified at the preliminary hearing held on February 4th, 2025. Mr. Hernandez, did you receive the notice of parole violation report, and other documents that were marked for identification purposes back at your preliminary hearing?
Yes, ma'am.
And did you have opportunity to review it?
Yes.
Today we have no witnesses, and it is now your opportunity to respond to the parole charges against you. However, you may remain silent if you choose to do so. Do you wish to testify?
Yes, I would like to speak on that, on the behalf of that. I admit to me manning up to the two dirty urines. And on the day of the without going to the CRT, that was the day Miss Miller was meeting everybody in the halfway house to do their routine monthly check. And I went to the store and bought cigarettes and I came right back. I didn't have time to go to CRT because she was meeting with everybody. And on the behalf of the vape pen, the agreement was that if we had the receipt and the original box it came in, that we could have it. That's it.
Thank you. Regarding charge 1, drugs, I make a finding based on your testimony today, as well as State's Exhibits A, C, and D. On charge 2, halfway house placement, I make a finding based on State's Exhibits A, B, E, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to your background history. So when I say background history, what is your plan? Do you have employment opportunities? Do you have a sponsor? Do you plan on going to a halfway house? What is your plan upon parole reinstatement?
Well, to be honest, during this whole process, when I first got paroled, the agreement was that the 3-judge panel approved my interstate compact, but they just denied my sponsor. So due to the fact, since they denied my sponsor, I was forced into the halfway house and I have to stay out here in Connecticut. You know what I mean? I don't have no family support out here in Connecticut. I'm by myself. All my family, when my grandmother passed away last year, everybody went their own ways and they moved out the state. So I'm by myself out here in Connecticut. And that's why I've been trying to relocate to go back to New York.
So in order to be in terms of the revocation process today, in order to apply for interstate, you have to be in the community for at least 3 months with no issues. And then at that point, you could reapply to relocate to New York through the interstate compact, but you have to be in good standing for at least 3 months and then request it through your parole officer, just so you're aware.
No, I understand that, but
Okay.
I was like how we're speaking right now. I was already approved through the 3-judge panel, my interstate compact. And I was, like I said, I gave my information, I gave my sponsors information, and they told me on a Friday, which was the last day, and I was leaving Monday to the halfway house. They said, you got 3 days to give us a new address. How can I give you a new address in 3 days and you're telling me this on a Friday and I'm leaving Monday? And so you're basically forcing me into a halfway house. I can't give you another address. So that's why I was speaking like how we're speaking now at the 3-judge panel. Like, you're giving me a notice of 3 days, but you're forcing me into a halfway house and it's Friday. I can't give you another address, and I have to wait until after 6 o'clock to get a hold of my people to try to see if I can get a family member to give an address. So I was forced to stay here in the halfway house when I got approved my interstate compact, like how we're speaking now. I understand that out in the community, you have to wait at least 90 days because I was speaking with that with Stickles. And she told me the 90-day period that I had to do, and Miss Miller as well. So it's like, I'm still getting forced to stay here when I don't have nobody out here. And the halfway house situation is kind of like messing me up because I'm only limited by so many hours to do what I got to do. And if I'm special parole and a parole environment, like I don't have that same privileges that I'm supposed to have on special parole as far as being in a halfway house as a parolee. Everybody says that it's different. We get different rules, but I still, if I'm in the halfway house, I have to obey by the same rules as a regular parole inmate in the halfway house, and it kind of like messes me up because I can't do the things that I want to do on my past, like to do legitimate stuff, you know, like to go looking for a job and job interviews. I got to get approved passes. Like with certain halfway houses, you got to put in a pass in advance. You know what I mean? It's kind of like hard.
So,
It's
so
like,
it sounds like you would have to go back to a halfway house this time as well.
yeah, and I'm being forced. Like, so how you want us to adapt into society when you're not even giving us the chance to adapt to society? You know what I mean? It's like controversial.
So a halfway house placement, it sounds, I mean, I know because you don't have any, it sounds like you don't have a sponsor in Connecticut. So what area would you want to go to?
Back to Hartford. That's all I know, because I know how to the transportation with the buses and the train. You know, I don't know New Haven. I don't know Bridgeport. Every parole officer keeps telling me to go to Bridgeport, but I know it's closer to New York, but I don't know nothing. I don't know the transportation. So God forbid if I do get lost out there and I miss the bus, now I'm being reprimanded back because I failed to report back to the halfway house. And it's like, I don't want to do that. I don't got no escapes, and I'm not trying to come back for absconder or escape. I'm a man. I'm gonna man up to my wrongdoing, like how I admitted to my dirty urine. You know what I mean? But you're not gonna force words on me like, oh, you absconded or you escaped. How do you know that? You're not standing with me. You don't know the bus schedule. So you know what I mean? It's controversial. And me coming back here doing this again is like, it defeats the purpose. I might as well just stay in jail and not go back out because I'm being held back for stupid stuff in the halfway house.
And upon parole reinstatement, do you need to look for employment or do you have a job offer?
Well, I've had numerous jobs and parole made me lose the job because they won't give me the pass to go out. And even though they confirm it in the halfway house, to be honest, it was like the Watkinson house was doing some foul stuff. And I didn't like that.
So you have to look for employment when you get out.
Yeah, I have to look for an employment. I had 2 jobs already lined up. And me being in that halfway house, it was a controversial thing.
Do you plan on doing, so you're looking for employment, being in the halfway house, do you plan on doing anything else while you're in the community?
To be honest, I'm trying to, I can't, I'm a professional barber. I'm a barber, so they won't let me work in a barbershop because they want pay stubs. They don't want the barbershop cash on hand. So I can't do the job that I know that I can do. You know, they're forcing me to do other jobs that I've never been trained to do. All right, I could work McDonald's and stuff like that, but you know what I mean? I don't want that kind of pay. I want the pay that I'm used to getting, the $25, $30 an hour. You're not gonna force me getting 15 and me not knowing what to do in McDonald's or whatever. You know what I'm saying? You learn, but that's not my profession.
So look for employment and work, be in the halfway house. That sounds like those are what you plan on doing while you're in the community.
Well, Miss Miller said she was helping me get into one of those reach beds and put me in a parole apartment instead of just putting me back into a halfway house. Because that was my only issue was with the passes being in a halfway house. I only get 4 hours to be out in the community, and then I'm stuck in the house all day.
Hey, Mr. Hernandez, anything further? Because I'm going to take a moment before I make my recommendation.
No, go ahead.
Okay, thank you. Hey, Mr. Hernandez, I see that you've been on special parole since September 2024. And since then, you had one prior top placement, and you were re-released. And then you were in the community for about 6 weeks, and you exhibit the same behaviors prior to your top placement as well. Mm-hmm. Taking all that in consideration, as well as your testimony here today, I recommend revoke and re-parole on July 15th, 2025, which is an approximate 6-month sanction with the following conditions. No contact with victim CB, halfway house placement and mental health evaluation, no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board, and your board review is scheduled on March 27th, 2025, which is next Thursday. The board may lessen my recommended sanction, adopt my recommended sanction, or impose a sanction longer than what I have recommended, being that you are on supervision until September 2029. So, but you'll receive the written decision from them within a week from next Thursday.
Okay,
All right, Mr. Hernandez, you're all set, okay?
thank you. You have a nice day.
You as well.
Oh. Did I mess it up?
Nah, you go.
Oh.
Good morning, P.O. Curry.
Good morning, how are you?
Good. I've seen you've been here for a while. We're gonna get started in about 10 minutes.
No problem, thank you. I just didn't want to miss it.
No, I understand. Thank you.
Thank you.
Good morning.
Good morning. He's on his way down right now.
Thank you.
Is Lopez on his way? He's coming down right now. Here's our long time. You close it over.
Morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning George Lopez, inmate number 393929. Today is Tuesday, March 18th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
George Lopez, 393929.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney,
Hannah Dean, for the record, on behalf of Mr. Lopez. Good morning, sir.
as well as your parole officer Curry.
Parole Officer Curry here.
This is a preliminary hearing, which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Lopez and P.O. Curry, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney, as well as the state, will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice or charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. P.O. Curry, starting with charge 1, reporting.
Charge 1, reporting. You failed to report to your parole officer as directed on Friday, February 28th, 2025. Charge 2, GPS. You failed to charge your GPS unit for the required 2 hours per day on February 26, 2005, and incurred 2 GPS shutdowns at 1:20 a.m. and again at 8:49 a.m. You removed your GPS unit without your parole officer's permission or knowledge on Thursday, February 27, 2025 at 8:56 a.m. Charge 3, curfew. You violated your GPS curfew on February 27, 2005 by leaving your residence at 4:58 a.m. Charge 4, program participation. You failed to report to the Ford Clinic for substance abuse treatment on Thursday, February 27, 2025 as required. Charge 5, obedience to the law. You were in violation of your special parole conditions. You were in possession of a used dirty glass pipe that is used to smoke crack cocaine. Your possession of this drug paraphernalia violates your special parole condition number 2. I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. Charge 6, drugs. On Thursday, February 27, 2025, you cut off your GPS unit without your parole officer's knowledge or permission and began smoking crack cocaine until you were remanded on Monday, March 3rd, 2025. During a telephone conversation with your parole officer on Thursday, February 27, 2025, you admitted to smoking and binging on crack cocaine.
The state has filed the following exhibits, starting with Exhibit A, P.O. Curry.
I'm sorry, hold on a minute. Exhibit A is going to be his Connecticut conditions of special parole. Exhibit B is the actual remand to actual custody. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, decision information summary. Exhibit F, prior top parole violation. Exhibit G, photos of drug paraphernalia. Exhibit H, the report from the Ford Clinic. Exhibit I, the East Haven Police Report. Exhibit J, GPS reports. Exhibit K, GPS conditions.
Counsel, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
Yes, we have.
Thank you. Counsel, Mr. Lopez identified Mr. Robert Cardona as a witness. Does he wish for Mr. Cardona to testify? Is that still his intent for today?
I don't believe at this point, potentially, if required, if we do get to a revocation hearing, we may potentially call that individual at that point.
Okay. So therefore, today we have no witnesses. At this time, the state will have an opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations. P.O. Curry?
This offender has been released twice within the last 3 months. The first time he was placed in the top program back in, I believe it was February, and I'm sorry, yes, January. And prior to that, he had asked for help. I got him a bed at the App Foundation and he walked out. After that, I placed him in top. He was released to the community, and within maybe 35 days, he again went on another binge.
Thank you. It is now the defense opportunity to respond, to make a short statement and testify with respect to probable cause and the severity of the allegations. Counsel.
Yes, thank you very much. As to charge one reporting, I would argue that no finding should be made for that charge. There has not been any evidence submitted at all to indicate that my client was instructed to report on that date and failed to report. There's nothing in the actual list of evidence as to that charge. So I would argue no finding for that one. As to charge 4, program participation, again, I would argue no finding. 1 missed session alone is not sufficient for the probable cause standard to be met. It appears as well from Exhibit H that was submitted that they were still actively trying to work with my client and they did have ongoing contact with him. So I would argue that there should be no finding. It doesn't appear that he violated program rules or, failed to participate, and it is a program participation charge. Charge 5, obedience to the law. I'm going to argue that there's no probable cause for this one. This conduct specifically does not fit under obedience to the law. My client was not arrested for any of the allegations here, despite police presence at the scene when this, allegedly occurred. And the photos submitted for Exhibit G are not enough to meet the probable cause standard. There wasn't testing done. There were no NIC tests done to confirm what any sort of residue on the alleged paraphernalia were. My client was not arrested for possession of drug paraphernalia, despite police presence. So I would argue that because of that, there's nothing in evidence indicating that there was testing or any sort of presumptive positives. I would argue that that is insufficient for that specific charge. And then for 6, I would echo my comments that I just made as to obedience to the law, but I would also note that nowhere in evidence do we have any sort of urinalysis or any sort of positive test results confirming that my client was indeed positive for illicit substances. This is an unfortunate situation. My client does struggle with addiction. I will note that previously he had completed the TOP program and had been doing well. Unfortunately, the nature of the beast with addiction, he did suffer a relapse, but I believe that he, was upfront with program personnel as, regard to that. So I do just want to know all of those things. I would argue that this isn't serious enough. My client isn't being served by sitting in jail. He will be served by being able to do some sort of intensive program. I understand the PO's comments regarding the ACT Foundation. However, I will note that I've heard not just from this client, but from a number of clients I've represented that unfortunately, specifically ACT Foundation, there are the presence of illicit substances oftentimes in that, even though it is a recovery setting. So I do just want to make note of that. My client is amenable to any sort of treatment that would be recommended. He would specifically like to do, I think, an inpatient program at a different location that would be accepted by his insurance. Again, he's not being served by sitting incarcerated. I don't believe this is serious enough to continue to revocation. Thank you very much.
Thank you. Peel Curry, anything further?
Yes, I did speak to Mr. Lopez on the 27th, the day I noticed that he cut his bracelet off. I spoke to him via telephone, and Mr. Lopez admitted to me that he had relapsed again and that he had cut his bracelet off, but he told me that he had the bracelet. So without getting confrontational, I said to him, what do you want to do? Do you want to turn yourself in? He said, yes. I said, okay, how about tomorrow morning, 9 o'clock? He agreed. So he did agree verbally to report to me on the 27th. In terms of program participation, the counselor at the Ford program spoke to Mr. Lopez on the 27th, and Mr. Lopez stated that he was going to come in. He stated that he had relapsed and he needed help. So there was counselor at the Ford clinic stated, if you come in, I can try and get you help. But Mr. Lopez didn't show up. In terms of the ACT Foundation having drugs there, I've had other clients going to the ACT Foundation and they've been released successfully. They haven't had any issues. So I don't understand what the issue with the ACT Foundation is. I put Mr. Lopez in there, found him the bed. He was there for maybe an hour or two, and then he walked out.
Thank you, Counsel.
Yes, just very briefly, as to the comments regarding ACT Foundation, I'm just indicating that this is something that has been a common theme I've heard from not just this client, but a number of different clients. I understand that there are some people who have success there. That's a wonderful thing. But I do just want to note that much like incarceration, this isn't point blank an area that is completely free of drugs, even though it is an inpatient program. I have had many people report that they've been faced with other people using and the potential of relapse. That was just my comments. I'm not saying that that happens every time. It is just something that I want to note. As to the actual, charge for program participation, again, I will just say Exhibit H doesn't indicate anywhere that my client is being, discharged from the program or that he was unsuccessful in the program. In fact, it does say that they spoke to him, he was forthcoming with them, and that they are recommending him to long-term inpatient treatment. So to me, that sounds as though they're still working with him. So I would argue that for that charge, the standard hasn't been met. Thank you very much.
Thank you. Peel Curry?
You need to show up in order to get the help to get to IOP. Ford Clinic was willing to help him get into an IOP program, but he didn't show up.
Anything further, Peel Curry?
No.
I would just note, I understand what you're saying, but the evidence has not been submitted to show that. This is a situation where the hearing examiner needs to find preponderance of the evidence. My argument, which is a legal argument, is that there is not sufficient evidence for that charge. Thank you.
And Peel Curry?
No, I'm all set. Thank you.
Thank you. I'm just going to take a moment before I announce my recommendation and my findings. Regarding charge 1 reporting, I make a finding of probable cause based off of state's exhibits A and D as well as testimony today. On charge 2 GPS, I make a no finding of probable cause on part 1 as the state failed to provide sufficient evidence to prove Mr. Lopez's actions meet the elements of the charge. I make a finding of probable cause on part 2 based on state's exhibits A, D, H, J, and K. On charge 3 curfew, I make a finding of probable cause based on state's exhibits A, D, J, and K. On charge 4 program participation, I make a no finding as the state failed to provide sufficient evidence to prove that Mr. Lopez actually meet the elements of this charge. Charge 5, obedience to law, I make a no finding of probable cause as the state failed to provide sufficient evidence to prove that Mr. Lopez actually meet the elements of this charge. On charge 6, drugs, I make a finding of probable cause based on state's exhibits A, D, H, as well as testimony today. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. Your revocation hearing will be scheduled within 60 business days from your return to custody. You will receive a hearing disposition, which will have a tentative hearing date listed. Keep in mind, all hearing dates are subject to change. And at the revocation hearing, a hearing examiner will determine if you violated the conditions of your parole. Okay, Mr. Lopez, we're all set with your preliminary hearing.
Mr. Lopez, once we get a date scheduled for the revocation hearing, I'll set up another legal call with you, and so will my social worker, okay?
Thank you.
Thank you.
All set.
Have a good day.
Take care.
Thank you, Peel Curry.
Thank you.
Yeah, finish it now.